the honourable member for Beaches East York.
Well, thank you, Mr. Speaker. I'm very happy to rise in the House today to speak to Bill S4, an act to amend the Personal Information Protection and Electronic Documents Act. As you know, Mr. Speaker, today's debate turns not precisely on S4, but on a motion to refer the bill to committee, in fact, before second reading. The concerns that I will raise with respect to the bill itself, Mr. Speaker, which go as far as to challenge the constitutionality of the bill, would likely be fatal to the bill at second reading, but we need not concern ourselves with that today. We need not arrive at a conclusion about how fatal these flaws are or how injurious they are to the bill. The motion before us today, Mr. Speaker, allows us to visit the scope and principle of the bill at committee and make, as required, amendments to these very principles and that very scope of the bill. Today, I would argue this motion warrants support so that this bill allows us so that we have the flexibility, Mr. Speaker, to properly study and examine and propose amendments to the bill at committee before the principle and scope are set. Let me set out a few reasons why this is particularly important in these circumstances and relating to this particular legislation, Mr. Speaker. Firstly, let me address the issue of public opinion that sets the context for which this bill and more broadly the issue of privacy concerns exists. According to a survey of Canadians on issues related to privacy protection conducted last year, 70% of Canadians feel less protected than they did 10 years ago. Only 13% of Canadians believe that companies take their privacy seriously. 97% of Canadians say they would like organizations to let them know when breaches of personal information actually occur. 80% of Canadians say they would like the stiffest possible penalties to protect their personal information, and 91% of Canadian respondents were very or extremely concerned about the protection of privacy. And of course, Mr. Speaker, this government cannot absolve itself from contributing or its contribution to this level of public concern about privacy issues. It's not just a matter of legislative lethargy, Mr. Speaker. That is, it's not just about the fact that we're well past the 5-year mark for the conduct of a mandatory review of the Personal Information Protection and Electronic Documents Act, an act that is by now well behind international standards, Mr. Speaker, and has failed to keep up with technological advancements in this digital age. No, part of the issue here, Mr. Speaker, is that this government has itself repeatedly demonstrated insufficient care for the personal privacy of Canadians through its own conduct. I would point, Mr. Speaker, to the fact that in 1 year alone, under this Prime Minister's watch, government agencies secretly made more than 1.2 million requests to telecommunications companies for personal information without warrant or proper oversight, Mr. Speaker. This is a government, Mr. Speaker, with a seemingly insatiable appetite and perhaps an addiction to Canadians' personal information. It's a government that needs to be constrained by effective legislation that protects the privacy and personal information of Canadians. It's a government that has no credibility on this subject matter. This is evident, Mr. Speaker, in the legislation that they have defeated in this House. In 2012, our NDP digital issues critic, my colleague from Terrebonne-Blainville, put forward Bill C-475, a bill to amend the Personal Information Protection and Electronic Documents Act that would have applied similar online data protection standards that exist in Quebec's Personal Information Protection Act. For example, C-475, Mr. Speaker, would have given the Office of the Privacy Commissioner of Canada the power to issue orders following an investigation. Excuse me. The Conservatives defeated that bill at second reading. They also defeated our NDP Opposition Day motion on May 5th last year. That motion simply called upon the government to close loopholes in existing legislation that currently allow the sharing of personal information without warrant. This government disregard for the private and personal information is evident by the legislation, too, that this government has brought forward. Bill C-13, the government's cyberbullying law includes lawful access provisions that will expand warrantless disclosure of information to law enforcement by giving immunity from any liability for companies that hold Canadians' information to disclose it without a warrant. This makes it more likely that companies will hand over information without a warrant, Mr. Speaker, as there are no risks that they'll face criminal or civil penalties for such conduct. There is a thread here, Mr. Speaker, that runs through the government's own efforts to access the personal and private information of Canadians through to their conduct and voting record in this place, a voting record that goes against the interests and concerns of Canadians, a voting record, Mr. Speaker, that denies the wishes of Canadians for greater protection of their personal and private information. In other words, Mr. Speaker, the issue before us goes to the principles underlying this bill. They need to be examined and amended at committee. For example, while S4 would make it mandatory to declare the loss or breach of personal information for the organizations in the private sector and penalize organizations that do not fulfill this obligation, the proposed criterion, Mr. Speaker, for mandatory disclosure remains subjective. It would allow the organizations themselves to assess whether, and I quote, "it is reasonable in the circumstances to believe that the breach creates a real risk of significant harm to an individual," end quote. More and most problematically, Mr. Speaker, still, Bill S4 adds exceptions under which personal information may be collected, used, or disclosed without an individual's consent. The bill would make it easier for organizations to share personal information with each other without the consent of individuals if the organizations are engaged in a process leading to a, quote, prospective business transaction. In other words, the bill allows, under certain circumstances, personal information of one organization's clients to be shared with another organization without their consent or knowledge. So here we run into some significant problems with this bill, Mr. Speaker. The amendments proposed contradict the very foundation of the Act it seeks to amend and serves to defeat what the Supreme Court called in R.V. Spencer the Act's, quote, general prohibition on the disclosure of personal information without consent, end quote. As the Supreme Court said in that recent decision, and I quote again, PIPEDA is a statute whose purpose is to increase the protection of personal information. The court in R.V. Spencer, Mr. Speaker, got to the heart of the issue here, thank you, understanding what this government has failed to understand about the issue of information privacy in the digital age, and it is worth quoting at length here, Mr. Speaker. So the court said, informational privacy is often equated with secrecy or confidentiality and also includes the related but wider notion of control over, access to, and use of information. However, particularly important in the context of Internet usage is the understanding of privacy as anonymity. The identity of a person linked to their use of the Internet must be recognized as giving rise to a privacy interest beyond that inherent in the person's name, address, and telephone number found in the subscriber information. Subscriber information, by tending to link particular kinds of information to identifiable individuals, may implicate privacy interests relating to an individual's identity as the source, possessor, or user of that information. Some degree of anonymity is a feature of much Internet activity, and depending on the totality of the circumstances, anonymity may be the foundation of a privacy interest that engages constitutional protection against unreasonable search and seizure. So from subscriber information, Mr. Speaker, the court has connected that information through to search and seizure. So, Mr. Speaker, we have at least before us a major concern with the principles of this Act, but seemingly, too, a bill that is simply unconstitutional. Leaving aside for the moment this latter issue, let me suggest by way of conclusion that if there is something in S4 that is salvageable, it can only be so if this bill moves to committee before this House sets in concrete the principles and scope of this bill and limits the kinds of amendments that can arise out of committee post-second reading. Thank you, Mr. Speaker.